Welcome to EUPrivacyForAll. Those sessions will deal with key topics regarding the General Data Protection Regulation that was adopted in December 2015. Today, let's focus on Data Protection Impact Assessments, DPIAs, and Article 33. A caveat first, this content is directed to non-experts, it's summarized, and the only objective is to inform accountable controllers and processors about their upcoming obligations. In those sessions, we will focus on key issues: DPIAs, notice and consent, further use of data, profiling, law enforcement requests, and many other topics. Article 33 is the article laying down key provisions regarding DPIAs. As you can notice, it is based on the notion of high risk for the rights and freedoms of individuals. In such a case, data controllers have the obligation to carry out an assessment of the impact of the envisaged processing operations. Other key points from Article 33 are the following one. First, if a data protection officer is nominated, his advice should be required. Second, there are 3 cases in which DPIAs will have to be carried out. First case is profiling, or in a more precise way, the fact of taking some decisions based on automated processing that could produce legal effects or significantly affect the individual. Second case is the large scale of special categories of data being processed, so basically processing sensitive data or criminal convictions and offenses data. Third case is a systematic monitoring of a publicly accessible area on a large scale. Finally, let's remind that each national supervisory authorities will have the obligation to draft a list of processing requiring or not requiring a data protection impact assessment. Let's focus now on negotiations and discrepancies regarding the drafting of Article 33. European Parliament was focusing on specific risks. It was suggesting that the entire life cycle management of personal data from collection to deletion should be framed, and it was also drafting 2 new provisions and 2 new articles on the definition of risk and on data protection compliance review. As such, those provisions were not retained. On the other side, the high risks wording proposed by EU Council was let down in the final text. Code of conducts were also retained as a key provision, and seeking the views of data subjects is also let down in the final draft. What's in the directive? So currently, there is no requirement for carrying out a data protection impact assessment as such, no equivalent of Article 33. But there is a specific mention of risks and the obligation of a data controller to assess those risks regarding security. So Article 17.1, paragraph 2, mentions this obligation of assessing risks. What should accountable data controllers do? Basically 3 things. First, carrying out a DPIA when needed. Second, keeping documentation of it. Third, reviewing the compliance with DPIAs each time there is a change regarding the risks assessed. One really interesting provision is in Article 33.3. it describes basically the 4 items to find in an assessment so that there would be compliance with the GDPR requirement. First, a description of the envisaged processing operations. Second, an assessment of the necessity and proportionality of the processing operations. Third, an assessment of the risks to the rights and freedoms of data subjects. And finally, the set of measures envisaged to address those risks and mitigate them. Tomorrow, it will be really interesting to get to the templates that might be released by the new Working Party 29, the European Data Protection Board, EDPB. It will also be really interesting to know more about EU consistency and, for instance, the lists that will be established by each supervisory authority regarding personal data processing necessitating a DPIA or not. Finally, having some specific guidance on SMEs or startups or else data processing might be really interesting.